Hello, my name is Randall Borden. I'm a family law attorney, practice in Virginia and Maryland, practice in the suburban counties outside of Washington, D.C., suburban Maryland counties outside of Maryland, and plus Frederick County in Maryland. So the topic of today is actually a continuation, a small series, I guess, is can children decide custody? And to summarize, the answer is no. Only the judge decides custody. So that leads to the underlying question of what input or how much input will a child have in a custody decision. I've talked about some topics already. Court-appointed lawyers for the children who'll bring the children's opinions and preferences into the court. I've talked a lot about to get an agreed order instead of a nasty custody battle. So today I'm going to talk about different kinds of evidence of the child's opinions or preferences. So you kind of have the idea of a child sitting in the courtroom in the witness stand, the judge here, the child to one side, the deputy, maybe there's a court reporter, a recording of everything the child says, and the child is looking out across the courtroom. There's this parent and the lawyer, and there's that parent and the lawyer, and the child is saying, good things about this parent and bad things about that parent, or vice versa, and it's pretty bad. So that's direct testimony. That is the testimony in the courtroom of the person, in this case the child, directly putting evidence into the court record. So that's what you see. Usually you see that on television, what most people think of a child giving their opinions and preferences to the court. However, there's a lot of other ways. As I talked about before, the court can appoint an outside independent observer or even an advocate for the child. That person will talk to the children, talk to both parents. They usually do a home visit. They may go to the school, get school records, talk to the guidance counselor, talk to the teacher. They could go to the doctor, get medical records, talk to the pediatrician, go to the police department, if it's gotten to that point, get the police records, get other court records if the child is in the system already, Child Protective Services, so there can be a lot of other written evidence out there that can be brought in as evidence. If there's already a police report, you get a certified copy of the police report, and that is evidence. If there are school records are difficult because they contain a lot of hearsay. They may contain a lot of opinions. You would try to present that. You get hold of the school records, then show it to the other side, force the other side to admit or deny that they're authentic records. You usually use a request for admission. If the other side admits it, then they can just come right in as a presentation to the judge. If the other side denies it, well, then you've got to have someone come to court and say, these are the real records. Or you might have the teacher come to court and say, you put this comment in the student's permanent record that says thus and such, and then do you recall doing that? Yes. Could you describe the situation? And then you have the teacher presenting it as direct evidence based on the teacher's memory into the court. If the teacher's note says the child always seems happy to see the mother, the child is never happy to see the father, then that's what you want the child's opinion, demeanor, happiness, sadness, emotional state, fearful state. That's where you want to bring that into the court. And you may have to have the observer there, the teacher, to provide direct testimony to the court. There is also expert witnesses. First thing to keep in mind is expert witnesses are very expensive. A lot of parents feel like the expert witness will guarantee to agree with me because, the other parent is terrible. So I want an expert witness. Could be a therapist who was retained before the litigation and the child was going to therapy anyway. And so now that you have the child's sort of regular therapist come into court, and that's always better than having, the parent's lawyer told the parent to hire this therapist who's the heavy hitter in child custody litigation, and then that therapist interviews the child for purposes of the litigation and is now coming into court to testify. The thing about an expert is an expert can express their opinion. So normally as evidence, opinion is hearsay and it is kept out of the courtroom. The informed, proper testimony of an expert comes into court as evidence. It's an exception to hearsay. For example, your neighbor says the child is always unhappy when they get off the school bus and have to go home to that parent. So that would be an example of hearsay, and that would be usually kept out of court testimony. However, if the expert meets with the child, maybe a session of multiple sessions of therapy, how do you feel when you have to go home, when you get off the bus? And the child could tell the therapist, well, I always feel bad. The parent takes away my phone, so I can't play video games, or I have to sit down and do my homework to make sure it gets done at the beginning of after school. I have to go to bed early, or I go home and the parent yells at me, or there's other people in the house that I don't like. Again, so the expert can gather the children's opinions, preferences, level of maturity. Is the child making it up because the child really wants to go to the parent who doesn't make them do their homework? Or is the child telling the truth or sincere? Is the child making statements that are appropriate for the level, for the age and maturity of the child? And the expert in court can answer those questions. They can testify, here's what the child told me, but I think it was parental alienation. I think the child was coached or forced to memorize this statement, and by that parent, which makes that parent the better parent. And that's how you can get the child's opinions and preferences into court without having the child testify in the courtroom. There are factors that the court must consider in awarding custody and visitation, both in Maryland and Virginia. The court has to go through each of the factors when they make a custody decision. And that's what you want to present to the court, right? My client has these factors in his or her favor, and here's the evidence that shows it. And the other parent either has a bad evidence for factor number 3, or the good evidence has no evidence, or the evidence that the other parent has is really kind of shaky or was made up right before the trial. So you can prepare your evidence from the day the custody case is filed up to the trial date. Now, keep in mind that if you suddenly become the best parent in the world during those few months, whereas before we were doing nothing, that's, any good attorney is going to use that against you. Like, hey, great, you just bought the child a car, but, that was 2 months ago, right? That's because you want her to say good things about you, right? Or, every weekend you've been ignoring the children, and now 3 months before the trial, you're demanding every single minute of visitation, right? Because you're pretending to be the good parent to show an artificial parent to the child, that this is something you came up with at the last minute. You realized got this major deficiency. You haven't spent a lot of time with your child, right? And now you're trying to make up for it all at the last minute, right? How much time did you visit with the child a year ago? And your answer is, well, as a matter of fact, a year ago, we went to a 3-day hike in the woods, and here are the pictures. And the pictures show, smiling, happy child, literally on top of the mountain, right? I mean, that's where you have an element of time to show a consistent opinion and preferences of the child. I always want to see all the pictures. What have you got of your child? Sometimes my client has nothing. I mean, or the other parent is the one that kept all the photographs. So that's not good. But if your client has, here's the child in the hospital room being born, right? And the father, the mother, and the child, and the nurse is taking the picture, right? And, every single picture is the parent and the child and the big smile and, the first bicycle ride or taking off the training wheels, their first piano lesson and the big smile and the bright, shiny eyes. The judge will see that. So you can't show the judge every photograph, but you want to have a selection of photographs. So you'd want a picture of the child's room in your house. What does it look like? What's on the walls? What do is it just a bare blank room, or is it covered with stickers and school projects and smiley happy or dancing ponies or projects of a boy or bow and arrow? You can see that photograph and you can infer that's a fun place. That's a child that's engaged and happy and lively and normal and vivacious. And so the judge can see that photograph, just that one photograph of the child's room, or of the child's piano recital, or of the child whatever playing football, or and the judge can say that's a parent that's involved, and the child has done all of these things, or regularly does piano lessons or sports or tumbling or swimming or whatever. And with that parent, and there's a consistent track, took a long time to make the 50 things, stuck on the walls of the child's room. Again, the time element, or the temporal story that one photograph can show is, the child did this at summer camp. The child did this on a birthday. Child did this, at the Christmas or the holiday vacation, or the religious. So that the one picture tells a story over a long time period, and it tells the judge the preferences and demeanor and opinion of the child. If a parent is able to get the child to do all of these projects, testimony, I'm quoting, it's not testimony, but that is conveying that fact that the parent, is a good parent. Maybe not the better parent, because that's still a decision to be made. But what the picture of the child's room shows, and it's got to be the regular room. I had a case where the other side, not my client, bought a whole room full of furniture a few weeks before the trial. And they just had it all set up, had all kinds of pictures there. And I just asked the parent, when did you rent this apartment? When did you buy this furniture? And he had to admit, a few weeks ago. Well, that's a good start, but my client had all of this child had furniture at my client's apartment for a long time. And it wasn't just, store-bought, newly purchased furniture. So the pictures, the evidence, the school records, the school meetings, do you talk to the teachers? Do you go to school? Do you go to the parent-teacher conferences? They're all on Zoom. You have no excuse not to go. Video conference, whatever the school system's using. Do you subscribe to the teacher's newsletter? Do you subscribe to the school newsletter? Do you show up for school? When was the last time you went to the doctor's office? When was the last time you went to the school? And you can get the medical notes. And you say, I went for this appointment. I went for this checkup. I went for this vaccination. So again, you incorporate an element of consistency and time into the records that you're going to show the judge, which shows the child's opinions and preferences without having the child there testifying and being traumatized in a courtroom in front of the parents. So if you have those records now, great, start putting them together. You definitely don't want to pay me to organize your paperwork. If you have some good pictures you want a judge to see, go to a copy store and get it done. You want to pay me or my assistant at my hourly rate to do that? Of course not. Do it yourself. You know what you want the judge to see, put it together. Typically, it's a 3-ring binder. So, it might be nice that your child did a picture frame made out of pasta noodles, but that doesn't make a good trial exhibit. So, kind of think about what can fit inside of a 3-ring binder, with 3 holes punched on the left-hand side. Direct testimony is the child testifying in court. We really want to avoid that. And even depending on the judge may just say no. The judge runs the trial. So the judge may say, I don't want the child testifying in court, period. So I don't want direct testimony of the child. Or the judge may talk to the child outside of the courtroom and get their opinion that way. You can get an expert witness. It's going to cost a lot of money. You can get people who essentially are experts, teacher, the doctor, or even a soccer coach, right? That the child is never on time, doesn't participate, doesn't like to go out on the field, is not a enthusiastic player. An expert doesn't have to be somebody with a medical degree or somebody with letters after their name. So you could qualify the person as an expert based on what they're going to testify to, perhaps get their testimony in that fashion. Obviously, school guidance counselors, it's what they do all day long, right? They deal with children, so they're going to be experts. Generally, therapist doesn't want to go to court to testify unless they're an expert witness already. If the child's going to therapy and the therapist is willing to testify, that's really good. It's also very rare. Most practicing therapists do not want to go to court. And again, there's a whole variety of other non-human types of evidence. We talked about pictures of the child's room showing 15 different activities. The school records, it's the law. School is supposed to keep records of attendance. The school records will express grades. The child lives with one parent and they're doing well in school. That's an indication of the child's best interest, but also the child's opinions and preferences for that parent. If the other parent has never been to school, has never been to the doctor, has never been to ballet practice, you're going to want that too. Maybe have another parent from ballet come and testify. I only see mommy at ballet practice. I've never seen daddy. I didn't even see the father at the end of season performance, where all the parents were there. And, they had the dinner and the performance and the children so that's an indication, an uninvolved parent. It's kind of an implied that the parent who's not involved with the child will not have a good opinion, will not have a preference for the parent that's not involved. That's an example of non-testimonial evidence that you can get into court that would show the child's preference and opinions maybe in an indirect fashion. So you should have this opinion with this conversation with your attorney in a great amount of detail. I am going to talk more on getting the children's opinions and preferences to the judge. So my name is Randall Borden. Again, I'm a family law lawyer in Virginia and Maryland, inside the DC suburbs. My office is actually in Fairfax City, directly behind the Fairfax County Courthouse. It's important that you like the video. It also tells me to do more videos like this. Subscribe to the video. You also get notification from YouTube when I post a new video. As I said, I have other videos that I've already done, so please check those out. If you agree with me, put it in the comments. If you don't agree with me, put it in the comments. If you want me to do videos on particular topics, put that in the comments also. Thank you very much for your time. I hope this was informative for you. Thank you very much, and goodbye.